tungkol sa other concerted activities, referenda on reduced demand, improved offer, Article 282 and Article 283. So, ano na? Tara na!
The court ruled that the detention or deprivation of liberty of the complainants was not done with criminal intent. It was the outcome of picketing carried to excess by person whose objective was not to inflict loss of freedom on the complainants but to weaken management resistance so that it would give in to their demands. Such conduct, while no doubt to be deplored, cannot be made a basis for a finding a probable cause that the crime charge was committed. Number 10. Other concerted activities. Among the concerted activities that employees may resort to in order to gain some leverage in pursuing their dispute against their employer, only strike and picketing are named in the Labor Code. There is, however, a recognition under Article 278 letter A of the right of workers to engage in concerted activities in general for purposes of collective bargaining or for their mutual aid and protection. This includes, among many others, boycott and such informal employee actions as sending protest letter to the employer, holding group members to discuss grievances, circulating petitions critical of the conduct of labor relations, and using the services of the media to publicize the existence of and the issues concerning a dispute with the employer. Whether mentioned in the law or not, concerted activities may be engaged in and they enjoy legal protection for as long as they carried out within legal bounds. The legality of these activities is usually dependent on the legality of the purposes so to be attained and the means employed thereof. For a concerted activity to be protected, it is not necessary that union activity be involved or that the collective bargaining be contemplated. A letter of only a handful of employees complaining against management malpractice is one such activity. A slowdown, while also a concerted activity, has been declared by the Supreme Court as an inherently illegal activity, essentially illegal even in the absence of no strike clause in a collective bargaining agreement, statute, or rule. It is a strike on the installment plan, a willful reduction of work for the purpose of restricting the employer's production. It is generally considered as inherently illicit and unjustifiable because while the employees continue to work and remain at their position and accept the wages paid to them, they at the same time select what part of their allocated tasks they care to perform of their own violation or refuse openly or secretly to the employer's damage to do their work, and in other words, they work on their own terms. A sit-down strike, also known as sympathetic strike, where the striking employees have no demand or grievances of their own, they strike for their purpose of directly or indirectly assisting others without directly relation to the advancement of their own interest, but only to show sympathy for co-employees dismissed by the employer is an illegal strike. The union's concerted violation of the employer's hotel's grooming standard by reporting for work with closely cropped hair or clearly shaven heads, which resulted in the temporary cessations and disruptions of hotel's operation, is an unprotected act and should be considered as an illegal strike. Number 11, referenda on reduced demand or improved offer. One of the innovative ideas introduced by the RA 6715 to the labor dispute settlement machinery is the system of holding referenda to determine acceptance by the employees of the employer's increased offer in case of a strike and by the employer of the employees' reduced demand in case of a lockout. This system, which is aimed at expediting the settlement of dispute through a determination of the will of the majority within 30 days from the start of the industrial action, is provided in Article 280, which, before the said amendatory law became effective in 1989, contained the enumeration of prohibited activities in connection with a strike or lockout. Article 282 provides that assistance by the Department of Labor. The Department of Labor, at the initiative of the Secretary of Labor, shall extend special assistance to the organization for purposes of collective bargaining of the most underprivileged workers who, for reasons of occupation, organizational structure, or insufficient incomes, are not normally covered by major labor organizations or federations. Article 283 provides that assistance by the Institute of Labor and Manpower Studies, the Institute of Labor and Manpower Studies shall render technical and other forms of assistance to labor organizations and employer organizations in the field of labor education, especially pertaining to collective bargaining, arbitration, labor standards, and the labor code of the Philippines in general. Number 1, education and research. The mandatory activities of labor organizations under the labor code are labor education and research. These are the activities referred to in Article 250P, Palacol versus Ferrer Calleja, 182 SCRA 710. The rights and the conditions of membership in a labor organization include the right to information on the provisions of the union's constitutions and bylaws, the collective bargaining agreement, the prevailing labor relations system, and all the members' rights and obligations under existing labor laws, and giving such information is the duty of every labor organization and its officers.